Hey guys, let's talk about the FDCPA, which is the Fair Debt Collection Practice Act, and who it governs. If they collect on the debt, but they did not originally own the debt, then they are governed by this law, okay? This is places like Portfolio Recovery, Midland Credit, LVNV. Those people are governed under this law. They're held accountable under this said law, okay? Collection agencies hired by the original creditor, debt buyers who purchase defaulted accounts even if they now own the debt, attorneys who regularly collect on debts, they are governed under the FDCPA as well, auto repossession agents or repo companies, collectors contacting you about debts, discharge, and bankruptcies, all of them are governed by the FDCPA. Who's not governed would be your original creditor, like Capital One or Discover. They are governed by the FCRA, which we'll talk about in another video. Government agencies like the IRS, student loans, etc., they're not governed by this law, okay? Businesses collecting debts that they're owed directly, they're not governed by this law as well. So what I need you to understand, if you get a letter or a call from a third-party collector, you can hold them accountable under the FDCPA rules. You cannot hold your original creditor accountable under this law. That would be FCRA, okay? So this means if you, say for example, Midland called you and said, hey, you owe a debt on Bansfield Pet Hospital, you can send them a debt validation and ask them to validate that debt in writing. You can also hold them accountable if they're harassing you, blowing up your phone, calling you too much, calling you before 8 a.m. or after 9 p.m. in your time zone. They cannot discuss your debt with other people. So if they call and your sister picks up the phone and they just go off and talk about how you owe Bansfield Pet Hospital like $2,500, they cannot do that. They're governed under this law, and this law says that they cannot do that. Reporting the account as disputed, once you send your letter, they're required to do that. A lot of people do not know, when you dispute an account, they have to update the credit report to state that the account is now in dispute or has been previously disputed. If they do not update that, that is a violation, okay? They cannot misrepresent the amount. So let's just say you signed, we'll just keep it going with Bansfield Pet Hospital. Let's just say whatever your client agreement, your contract or agreement or whatever the case was with that company, and you did not pay on it. If in that contract or paperwork, it does not state that if your account is sold anywhere else, that they can add like interest and other fees, they cannot do that. So Midland cannot just buy over that account and say, hey, we feel like throwing on $1,000 in interest now that we're trying to collect on this. If it's not in the original contract, they cannot do that. And again, they are governed by these laws. So I definitely recommend, if you are following anyone or anyone is giving you tips, that they know what they're talking about, because sometimes you guys are going after companies and you're quoting stuff that does not even pertain to them. You cannot hold the the original creditor and say, you know, hey, you didn't validate the debt. That doesn't go. Okay, so make sure that you are following for more tips. If you have any questions, please make sure that you let me know and drop them. And I hope you have a beautiful day.